talks because of this COVID-19. Learning has been, like schools and colleges have been stopped, but learning has not been stopped. Sharing of knowledge has not been stopped. Eminent personalities like Sneha Latha ma'am, they have come forward to share their knowledge. Today we are going to have this session on Hindu Succession Act with reference to women rights. It's my privilege to introduce today's resource person, S. Sneha Latha ma'am. She's assistant professor and in Bhaskara Law College, Hyderabad. She has pursued her MBA, LLM, and she's pursuing her research PhD in Andhra University. She's got a decade of experience in teaching with law, and she's a guest faculty in management. It's a privilege, madam, to
Thank you.
invite. Now I invite Sneha ma'am to deliver the talk on Hindu Succession Act with reference to women rights. Welcome to you, ma'am.
Thank you, sir. Good evening, very good evening, all of you. Today I'm talking about Hindu Succession Act with reference to human rights. Why? Because I'm choosing this topic. In August 2020, 11th August, there was a landmark judgment is given regarding women right into the Succession Act in the ancestral property by way of um, I mean, so that is the main reason I'm choosing this topic. Regarding that, I'm starting now. Properties. Actually, the properties are two ways we are getting. First one is self-acquired property, and second one is uh, ancestral property. So, ancestral property acquired by a grandfather with the generations to generations. At present, three generations is compulsory in the ancestral property. At with present generation, we can know that. So here, ancestral property, if any undivided families in Hindu joint families, if any acquired any property, his head of the person is a karta and belong to the other person is comes under the category of co-personers. So these are the persons are eligible to get their joint family properties. Coming from that self-acquired property, we are know about that self-acquired property by his own or independent property is acquired by himself. That is called as a self-acquired property. So my first slide is regarding the introduction. It is given by the one quotation. I measure the progress of a community by the degree of progress of which women have achieved. This quotation is given by Dr. B.R. Ambedkar. Why? Because if a woman is achieved, then only we can get a sustainable development in India, not only in India and world level also. Um, uh, there is a misconception regarding that women of Vedic times did not have any property right, and these rights are created by the succession. For example, by the statutes like Hindu Succession Act, and so many acts is there. But this is a misconception. Why? Because in ancient period, we can talk about the Vedic ages. The status of women was better than in the subsequent period. In those days, woman was a great respect and enjoyed considerable rights and privileges. Regarding that daughter, when we look into the daughter, during that Vedic period, daughters was educated and possessed full religious uh, full religious full religious privileges, the right of brothers, less daughter. There is no misconceptions regarding the daughter and sons, they gave equal opportunity while they're learning education, and not only for the education, they achieved some roles also. They played some roles and they enjoyed some privileges in, especially in the daughters. In the right of brother less daughter to inherit her father's property was recognized since in Rigveda, especially in Rigveda, they are recognized in the proper inherent rights of the properties regarding the woman. However, in cases where the property, even though she had a brother also enjoying some rights regarding the inheritance, coming from the wife. In those times wife is a very plays a very important role. The concept of the joint owners of the property by husband and wife was well recognized in Vedic time, and it has been generally agreed upon by Vedic scholars that wife had a right to joint ownership of the property along with her husband. So he gave, and not only for that, and without any ceremonies, especially in the grahastha wife is playing very important role to conduct any homas and any cultural things, and so that is the main role is given in the Asian time. After that, coming from widows. Widows also in Vedic time is recognized, and they had only one right. Is only the one right, that is a maintenance part. In the absence of her husband or son, she had a right to maintain from her husband's estate. In case of a minor son, she has a great, he has a right to inherit the property as a guardianship of minor, but no right to alienate that property. That's it doesn't. It means that he doesn't. He doesn't have any right to sell that property. Only the having a enjoy that for the maintenance purpose. That from that period. So in Smritu's period, that is very very. One minute. Sorry, Manusmriti. It is very very important smriti in India. We can know that. So especially in Manusmriti, during he doesn't give any rights to the woman. And such period, Manu talking about the text 106 stated that on birth of first son, he freed from debts and to names, and therefore he is worthy to receive whole estate. This has worship and the law of inheritance. The son born to a person was considered to be competent to offer obligation to the names of the deceased ancestors and procure salvation to them. Therefore, he was given right by inheritance to the estate of the deceased ancestors. The son, grandson, great grandson, the son, father, and grandfather were considered competent to worship the names of the deceased ancestors. The property right has not provided to the daughters and female descendants in Manusmriti. He does not give any priority to that women rights regarding that Manusmriti period. In Narada Smriti, it doesn't recognize the daughters' rights But in Yajnavalika Smriti, it is a great opportunity is given to the daughters, and at the same time, there was a freedom to women in religious and public activities to select their male partner, right to property and inheritance, economic and occupational activities, and freedom also is given in Yajnavalika Smriti. In this Smriti, especially, is given an explanation regarding that Sridhana and who are our persons are eligible to get a Sridhana after that having the after the deceased person of the woman. So it clearly says that in Vyavaharadhyaya, this is a part of Yajnavalika, is especially clearly mentioned that Sridhana, slokas 143 to 148 of the Vyavaharadhyaya part is describes the Sridhana. Sridhana, that Sridhana includes gifts from mother, father, brother, or husband at the time of marriage. What they have to receive the by way of gifts or anything. So that is called as a Sridhana. If women have a daughter, then the legal hair, then she is, I mean, the daughter as a legal heir of that Sridhana property. If in case of her husband or father will be heirs of the Sridhana, if if she doesn't have any girl child or daughter, then the father and husband is eligible to acquire that property. If the woman has no any heirs after her death, Sridhana will go to the side of her husband's brothers. That means here the father's side doesn't have any right to acquire that Sridhana property after her death. Only the husband's brothers are acquired to Sridhana property. This detailed description is explained in the Yajnavalika Smriti. So basing on these Smritis, then we understood that man was treating woman as his personal property. Because of the dominance, we can say, and because of his dominance, and in olden days they are conducting pitru karma, and these are the ceremonies we have to conduct. Only the son is eligibility, so they are given a priority to the son. If doesn't have any sons, they are handed over to their brothers sons. They didn't have any right to do any those ceremonies as a woman. So that is the main drawback in that Smriti's period also. In the society, is basing on this Hindu religious text treated women as dependent, requiring protection, and considering them is capable of exercising independent authority. Even in medieval period also, when we look into that, we didn't have any much more priorities given to the women. They didn't even treat as a human being also. They always looking into as a property. It's look like the property. When even in king's period also, women are treated like as a property by the men. So after that, in international level, some conventions and treaties are entered in Beijing platform in 1995 is recognized women's rights to inheritance, ownership of the property should be recognized in Beijing platform. In international level, apart from that, UNO conventions are regarding, they are also recognizing the women rights the conventions and the elimination of all forms of discrimination against women, CEADAW. This is, we can call it as a shortcut shortcut form. In 1979, they are also recognized, and they gave the resolution was passed in U.S. General Assembly. Is the International Bill of Rights of Women. It refers to the rural women rights to equal treatment in land and agrarian reforms is a process. So that means not only for the not only for that I mean the mobile properties, either it is a mobile property or immobile property. They give the importance. They are recognize the importance to the agriculture lands also in international level, through the conventions. Coming from in India, coming from in India, the first after the battle struggles, we are given an importance to the we are given the importance to the importance to that British period also. They are started as a resolution. They are founded as resolutions, and they started and they wrote enactments, Women Rights Amendment Act in 1929, especially regarding the property rights. Here also does not describe properly as a woman, but we can say this is the first legislation to recognize women rights regarding the regarding the property rights, especially the property rights in the ancestors, ancestors, ancestors. Ancestors. Beyond that, in Hindu Succession Act, before that, we have so many amendments also is there. Apart from that, Hindu succession, before the Hindu, I mean, before the Hindu Women's Rights to the Property Acts 1937, it deals with rights of, especially it deals with rights of widow on her husband dying without son, or entitled to the share of the property as that of his son. Hindu women in estate is limited interest is given into the Hindu Women's Rights to the Property Act 1937. It does not provide any rights to the daughters here. Is only focused regarding that women widow rights, Hindu women rights. It does not recognize in Hindu women's rights. Actually, we are having a two schools in historical level, Nitakshara school and Dayabaga school. Nitakshara school is male dominating states, apart from the West Bengal and some parts of the Orissa. Remaining parts are followed by the Nitakshara law schools. Nitakshara law schools, it's the sub schools is also is there. The group, the Nitakshara law school is given importance to the only male members. They didn't give any priority rights to the female members in Nitakshara law school. The father's power over the property is qualified by the equal rights by both enjoyed by a son, grandson, and great grandson. These are the generations are prescribed in Mitakshara Law School. They did not even prescribe as a daughters, and they did not give any priority to the daughters, mothers, and widows also in Mitakshara Law School. The second school is Dayabaga School. In Dayabaga School, obviously it's opposite of the Mitakshara Law School, and here the female dominating societies, we can say, is follows the Dayabaga School, especially in India. West Bengal, Orissa, some of the parts are Still, we are followed by that Dayabaga school. In that Dayabaga school, in that Dayabaga school, females are having a entire property rights also. Here, the son has no automatic ownership right by birth, but he acquires the property on the demise of the father only. If then only he can get any right regarding that ancestral properties, whether it is ancestral or properties in Dayabaga school. Um, After that, the Hindu Law of Inheritance Amendment Act 1929, this is the first legislation in direction of extending women rights, especially in the daughter's property rights. This provision of the act inheriting the female regarding that women regarding that property rights, and they are added the female heirs in the property rights, and he added this daughter, he added the right of the daughter in that Amendment Act 1929. After that, the Hindu Women's Rights to the Property Act 1937 was is amended, and these are the enactment was passed in Hindu Women's Rights the Property Act 1937. It especially focused on predeceased son's widow was placed before the daughters in order of the succession. That means daughters' rights is second category, widow rights are the first category given important to the Hindu Women's Right to Property Act 1937. And here it deals with, we are know that the rights of the Hindu widow on her husband dying without, or widows are entitled to the share of the property as that of a son. So if our widows are entitled to the share of the property as that of the son, that are inheritance in the property. Hindu woman estate is limited interest. This act is give birthright. This has give a better right on the widow, but not a daughter. Especially, this act does not provide any right to the daughters in the Hindu Women's Rights to Property Act 1937. This is the main drawback regarding this act. After that, Hindu Succession Act 1956 was enforced. Before that, the Hindu Rights to the Properties Act 1937 was repealed, and that there was a demand for Hindu law codification. Then the government was appointed the Hindu committee, especially for that, codified for the personal laws. In 25th January 1941, under the chairmanship of the B.N. Rao. That is the main reason this committee, we can call it as a Rao's committee. Here, Rao's committee is codified, the Hindu codified of 1947. Was in a part vigorous attempt to incorporate radical reforms. Hindu law is in gradual stages. The legislatures passed Hindu Succession Act 1956, which became law on 7th June 1956. It was enforced in India. The main objective of the main objective of the main object of the Hindu Succession Act 1956, it removes the inequalities between the man and woman, son and daughter, mother and the wife and husband. This is the main conception is developed in the Hindu Succession Act. Act. Um, Regarding the property rights, it evolves the list of heirs entitled to succeed on inheritance based on natural love and affection rather than on religious efficacy. This is the first law which sanctioned absolute property rights to women. It has granted equal. It has granted equal rights to the woman, I meant to say daughter, mother, widow, and son. So this is the equality rights is given in Hindu Succession Act, and then in Hindu Succession Act, the property rights are divided into class 1 and class 2 heirs. So in class 1 heirs, we are added, the women are added in class 1 heirs of deceased male Hindu, and they are become eligible to obtain property rights from their ancestor. However, it had a restricted right in respect of ancestral holding. It has provided right of it has provided right by birth to male alone. That means to say right from birth, the woman and a man also is eligible to get a property as a we can treat it as a co-personaries of nature of the property. It starts from the Hindu Succession Act 1956. Before that, we didn't have any property rights, and we cannot treat it as a co-personaries. Um, the personal laws of various communities are not subject to the constitution. Thus, the constitutional law mandate of gender equality, which is to the bound, which is to the bound of found in the Article 14 and 15 of the Indian Constitution, need not be taken into the account by community determined personal laws. This affect that personal laws are given a free hand to discriminate against women. As per especially in Indian Constitution, Article 14 and 15 is describes. The states that all people should be treated equally and no discrimination can be made relying upon the gender. The article itself it says there is no discrimination between the race, religion, caste, sex. This definition itself indicates that there is no discrimination between the gender. But the Hindu Succession Act, some of the sections are given, there is a there is a discrimination regarding that male and female, regarding that property right. Male is a co-personary property in respect to eradicate such inequality, of the section 6, especially in section 6 of the act is amended by way of Hindu Succession 80 Amendment Act number 13 of 1986. This was inserted a new chapter 2A, especially it's given the is recognized they eradicate the barriers between the gender discrimination. Section 29A, 29B and 29C in Hindu Succession Act It confers equal rights on daughters in co-personal property at par with son. This amendment was removed gender discrimination of exclusion of daughter from co-personal ownership, which led to the creation of the socially precious dowry system with its attendant social ills. By such enactment, a daughter was conferred the status of co-personal along with her father, but a daughter married prior to the 25th March 1989 was prohibited from claiming such benefit. After this enactment, this is a equal right of the daughters in co-personal property is recognized in a center, not only for the state level, at center level also. The so many amendments also is added. After that, after the 80th Amendment Act 1986, after that, as for the state-wise, Tamil Nadu, Kerala, Karnataka, and Maharashtra, they are only amended their own separate acts regarding that property rights, especially in the women. After that, the central enactment was added in 2005. This equal right of the daughter in co-personal property was inserted in the Central Act by the way of Act 39 of 2005. It clearly specified daughters and son has a become co-personal, and both of them having a equal right to the ancestral property right from their by birth. Changes occurred before and after the amendment. Hindu Succession Act. So, Section 4 of the Hindu Succession Act, before the enactment 2005, in Hindu, inheritance of agricultural land is subject to the state level. That means it cannot interlink with the Hindu Succession Act. Sorry, it was mistaken done by the PPT HSA, Hindu Succession Act. But after 2005, inheritance rights in all agricultural land are subject to the Hindu Succession Act, but not the state level. This was his major change in 2005, especially in the Section 4, Clause 2. After coming from the Section 6 of the Hindu Succession Act, before the enactment 2005, son has independent by birth in joint family property. We are not about that. Here, the daughter doesn't have any right to the co-personal as a joint family properties. That's named to the ancestral property. But after 2005, son and the daughter both have right and liability from the birth as a co-personal property in a joint family property. That means after 2005, everybody, that means every human being is an equal right from their joint family properties. He can enjoy the ancestral property. After that, Section 23 of Hindu Succession Act, before 2005, in a dwelling house where members are residing, no female heirs can claim partition, and daughters have right of residence only when she is deserted or widowed. This is in 1956 Act is specifies that this definition is repealed, and in 2005 they are now saying that whether the daughter married or unmarried have the same right to reside and in and to claim the partition of the parental dwelling house same as son. Um, same as son. Section 24, Section 24 of the Hindu Succession Act, a widow is not entitled to inherit the intestate property as widow if on the date the succession open she has remarried. This point is removed in 2005 after the amendment. A widow can inherit the property even if they remarried also. And section 29a b and c of the in 1986 this was is also is given the importance in the same thing here. In section 23 and 24 especially is given. So whatever the changes is in 1986, the same changes is in central level, they are added in the section 23 and 25. Regarding that, the major judgments, we are quoted in few major judgments here. Nana Jamma versus State of Karnataka. This case is delivered the decision in 1999 AIHC 2000 page number 2003. Here this case, the constitutional validity and whether the Article 14 is any conflict between that, if any daughters has enjoying any right regarding this, especially the Karnataka here after implementation of the given the rights to the equal rights to the women, especially in the co-personal property. One of the person is to file a case, is questioning them the validity of the Article 14 through the Section 6 of the Hindu Succession Act. The constitutional validity of Section 6 was inserted by the Karnataka Act number 23 of the 1994. After that, the case was filed, where a daughter becomes a co-personal and is entitled to the co-personal property. The challenges in the instant case was that the Act makes a distinction between the daughters married before and after the commencement of the Amendment Act and is violative of Article 14. The court held that the provisions is not discriminatory. The court sustained the classification on the ground that the daughters, in the absence of statutory legislations prior to the amendment, used to get some share of the property by way of gift or dowry, and they like. This decision is given by the Nana Jamma's case. There is no discrimination. There is no discrimination between the men and women, and they are giving. They have a. They are maintaining the equality rights to the. Equality rights to the Indian Constitution also. In Prakash versus Pulvati case, 2016, volume number 2, Supreme Court cases, page number 36, is given that judgment. Here, two judges bench headed by Justice A.K. Goyal held that benefit of the 2005 amendment could be granted only to the living daughters of living co-personaries as on 9th September 2005. Section 6 was prospective in nature and would apply prospective nature and would apply to the apply only if The co-personaries and daughters were both alive as on 9th September 2005. The prospective, what is the meaning of the prospective? Here, the judges are clearly specifies that the prospective means from that date onwards is eligible to get a co-personary property. That means 9th September 2005 onwards, this this conception, the section 6 is applicable the living daughters of living co-personaries as on 9th September 2005. This is a um, yeah. This is the I mean, this is the word is prescribed, and in the Prakash versus Purvati case. After that, so many discussions is held on that. After that, the Dhanamma versus Amar, they file a case regarding that application of the section 6. In this case, the court held that section 6 was applied retrospectively. That means before the who are 9th September 2005 before are all also are eligible to get that property. I mean to say to acquire the co-personary property. That means the retrospective. So here retrospective here, here in this case the father had died in 2001 and leaving behind two daughters, two sons and a widow. In the court held that it is the very factum of birth in a co-personary that creates the co-personary and entitled to equal share in the co-personary property, even though the father was not alive when the substitute section 6 comes into the force in 2005. This is the decision is given in Dhanamma versus Amar case. So here, almost all of the persons are getting confusion whether the co-personary property we can acquire, either we have to follow retrospective and prospective. Then the landmark judgment is given in 2020 in Vinita Sharma versus Rakesh Sharma. The decision is given in 11th August 2020. In this case, eradicated the barriers between the retrospective and prospective. We can say the landmark judgment it protects the women's rights, and they would have equal co-personary rights, and they would have equal co-personary rights in the husband, Hindu undivided family, I mean to say the joint families, regarding the property by virtue of their birth, and could not be excluded from inheritance. This right of the daughters was one best over by her birth and would remain unaffected by the date of the further demises. That means there is no conflict between the retrospective and prospective. They have to follow women and the men and women are acquiring the co-personary properties by from birth only. Here the Supreme Court has clarified 2 points, especially in 2 points regarding that conflicts. Co-personary, the first point is that co-personary properties, co-personary rights are acquired by daughters on their birth. It is clearly specified in this decision. And the second point was that fathers need not have been alive when the 2005 amendment to the Hindu Succession Act 1956 was caste. This is the two points are specified in Vinita Sharma's case, and the conflict also is eradicated, and it's given the judgment. It gives the free from limitations imposed by the dates of any legal notifications. Though the judgment engages rectifying one of the discriminatory social practices, it would require no less than a behavioral changes in the mindset of the Indian society to fulfill the goal of gender parity. Um, Most of the Hindus still today also they are led by the teachings of Smritikaras rather than Hindu Succession Act 1956. Um, um, under which daughters, mother, and wife get equal share along with the deceased, along with the son of the deceased. On the other hand, Christians and Muslim women do not get the same property rights as none in their especially in the Christians in Bible also, and Muslims in Quranic also. It doesn't specify the women rights. Simply, they have specified the maintenance rights in Muslim law and the Christian law also. They only get the maintenance rights here. Uh, After the changes are occurred in future, it may be a uniform civil code is arises are implemented in India. Then we can the Christian women and the Muslim women also is getting equal rights to the especially in the property rights. Um, After years of struggle and many hurdles on the way, women have succeeded, especially in Hindu women have succeeded or gained the justice to have equal rights as men. I hope, basing on this judgment, I mean the Vinita Sharma's case, basing on the judgment, I hope a drastical changes may be occurred in future.
Thank you, madam. Thank you very much. It was very informative session, and you have covered all the points. What are very important for the Succession Act, and also you gave examples and you quoted which reference and all. Thank you for your time, and thank you for making this session to happen. I thank all the participants, Sridhar Babu Sir, Bhagavad Gita, I don't know names, Sir, Bhagavad Gita, all other participants who have participated in this. Thank you so much, Sneha Latha.
Thank you, sir. Thank you very much, sir, for giving an opportunity to talk to share my knowledge.
Thank you, madam.